And oh, and now recording.
Sorry, it was paused. I just noticed that, so we missed the beginning chunk of the meeting. Whoops.
No problem. Kelly, you want to take the next slide? We did. I'm sorry, ombudsperson update. Shannon.
Okay. Good evening, everyone. I hope everyone has taken the opportunity to review the very important pieces that we're trying to get your support of. One is around first of all, can everybody hear me? I feel like I'm talking kind of low. Okay, great. The first is around resolution. The resolution is designed to reestablish or reconstitute the Delaware State Parent Advisory Council. This was what was a very important body, and it is comprised of public school parents from across the state that are appointed to participate. And one of the key functions of the state PAC will be to actually institute a subcommittee of that group, and that group would actually be responsible for the oversight of the Ombudsperson program, and that would be the Educational Equity Council, and it outlines who actually would be able to be appointed to the Equity Council. So that's the first order of business, is to see if there's any questions around the resolution. And then the second order of business is to get everyone's feedback and hopefully approval for the legislation that would codify the Ombudsperson program office itself. So just want to open up the floor. I don't want to go through it line by line. Like I said, hopefully everyone's had opportunity to read it, but I'm happy to answer any questions or get feedback or comment. I do want to say before we do that, both are really important if we're going to have a vehicle by which families can get support, right? That's independent of the educational system, working with, but independent of. And currently, as a state, we do not have that. We don't have a formally established family and community engagement office within the DOE currently. And so, which makes, I think, in my opinion, both really critical, as a critical need for parents as a way to help navigate through the system, to be supported by the system. And that, we hope that would actually lead to that would address more systemic issues, so that we don't even have to get to the point where we have to involve litigation, right? But there's a process in place that is supportive of families and students. So with that, any questions, issues, concerns regarding the resolution first? Okay.
Hi, Chuck here. I don't know where the hand function is on this thing, or I would raise my hand. I do have a question about the resolution. There's a lot of organizations cited in there to be part of it, be members of this group. Can you tell us who else has reviewed this so far? Was it, did we have any school district or charter school leaders, superintendents? Did we have Department of Education or anybody who took a look at this and weighed in on it?
We've had some of our legislative partners that were around from the beginning, folks like Nambi and Tizzy, Kim Williams, I believe Laura Sturgeon has opportunity to review it as well. So we kind of shopped it around to legislators, and we have not engaged, we have not sent it, I would say, to superintendents. No, we have not done that. But the resolution itself, again, the entities though that will be represented on this the Education Equity Committee, there will be representation from those same entities. So there would be a representation from the schools, there would be representation from the teachers union. Those will be appointed entities or organizations that we would be a part of the governance piece.
I also see Bill's hand. Shannon, would you want Bill to also give some?
Yeah,
time?
sure, Bill, because I mean, he helped to send it around. So I didn't personally, but maybe Bill did. Bill?
Yeah, I just want to make everybody aware that both the governor's office and the DOE, the secretary, and Emily have been supplied it quite a while ago, several weeks ago.
Any other questions, issues, concerns around the resolution?
Chuck, you found it.
Thanks, I found it. Now I gotta find how to turn that off. It's under reactions, there we go. Okay, well, I suggested this get run by some people at the school districts, just because I would feel personally more comfortable, and charter schools. I see Aaron there. He's always reminded me just by his presence. Some of the school and district leaders, I don't know that there'd be any resistance to this, but I would feel more comfortable endorsing it as a member of this committee if I knew that more eyes were on it. As it stands now, I'm going to abstain from the vote, but I do think that we do need some more eyes on it, just to see if there's anything that's, that from their perspectives that they would see here. Thank you.
Mm-hmm. Well, I would like Aaron to weigh in as a charter leader, and it's been kind of been in some of the initial conversations. What's your fit? Yes, I'm totally putting you on the spot, sir.
I'm used to it. So I have seen it, and I know that it's been shared with members of this committee ahead of time. And I've seen some of the earlier versions of it as well. So I do think it is something as one of many different leaders, district charter for public schools, that I think it does give more voice to the community in some of the ombuds person decisions. I think it also, while it does provide more oversight, I think it also give more credence to decisions and the ways that the ombudsperson group is working as well. So if there's a group that can advocate for them and say, hey, we weighed in on these certain ideas and we have this feedback, then I think the work that they do can be received more by the community. To Chuck's point, I do wonder. One, I recognize the fact that as a settlement committee, we are a recommendation committee, and so it's advisory, and I recognize that. At the same time, I do wonder if there'll be more input if we do wait. I don't know if it will be more, but I also recognize everyone's right to abstain. Would love to hear from the group if you want more people to weigh in before we move to the next slide, which is whether we support a resolution or not. Just, if we do, as our committee were to recommend it, then it will be pushed to the full rating consortium for review and shared there and discussed there, which I would imagine would also include the need to pass it on to more district leaders. So I would say CAOs, FOs, as well as chiefs, superintendents. But I would also think that more community groups could weigh in before it gets to the writing consortium as well. So I think there would be more time for people to weigh in if it did move from this committee. So I'm open to the group for the conversation of, before we take a vote, so I'm taking a pre-vote, the conversation is, will we want to move to the next slide? Yep, right there. Thank you so much. To vote or not on this, or and then also, to Chuck's point, share it with different district leaders, share with more community groups, and have more feedback before it's the writing consortium meeting, or to wait, get that now, which would then delay it to go into the writing consortium.
I've got a question related to this sort of, Aaron.
Yep.
Shannon, will this be considered, it's independent, so will this be considered kind of part of government or no?
No.
All right. And
yeah, it will not be considered part of government. And okay. That's stipulated in the settlement that the entity it's designed to be non-governmental. Yeah.
Exactly. And do you think, what power will it have?
Right. So it's embedded in the bill is the ability to provide additional oversight of the various federal titles, right? So like the organization itself would not be empowered to, come in and say stop anything necessarily, but it needs to be a part of the advisory when we're talking about when we're doing different regulations and the like. So the monitoring pieces, to be able to provide additional reporting and around like in the opportunity to actually get the same kind of data that the states, the educational systems receive in order to properly analyze it and then begin to provide recommendations, then influence those things. So it's definitely, the oversight is actually more, it lends itself to an advisory and support, right? It's not authorized to, stop anything necessarily, right? But it's meant to be an added to the advisement arm.
Right, it can call attention to things. It can
Yes.
call attention.
Mhm.
Recognizing Chuck's hand again.
Thank you. You did say something that I do think if the motion is structured in a way that it says we endorse it with the understanding that we will circulate it or that it will be circulated to the various stakeholders that are in here listed for their feedback, to provide that information to the big consortium, then I could support that.
Anyone else?
May I ask a clarifying question, Shannon? This is Neil.
Mhm.
The distinction between the resolution and the bill. I guess that's,
So the resolution establishes the PAC, right? And there, of course, you can't put a fiscal note in a resolution, right?
right.
So the resolution formally establishes the PAC and then the Education Equity Council. And then the bill itself actually establishes the office and the program, I should say. And that's when you get into all the different entities that will need to be represented as a part of the office, and the fiscal note is included. And it outlines more of the scope of work that's in the program itself that's not in the resolution. So that's kind of the difference between the two.
That makes sense. Thank you for clarifying that. And I suppose the political decision for you all, like, it seems like you could authorize a program with just a bill, not a resolution, but you've thought about it more than me. So thank you.
Yeah, and that was actually we did that under the advisement of one of our legislators partners who thought that it would be an easier sell, I would say, to make sure that we got the office, the DSPAC established through resolution, because there's no money attached to that. And so, some of the major hangups, although the money that's being proposed, the fiscal note that's being proposed in the bill was already agreed upon, at least the initial investment has already been agreed upon in the settlement. So that it was just I think a strategic way to get both things done at the same time. Thanks, Neil. Anyone else?
With no other discussion, to Chuck's amendment, the vote would be to support the resolution and support the bill with the dissemination of the resolution and bill to the impacted parties, as well as I would also add in any other groups of interest. So I might reach out to groups on this thread, but also I know there's a lot of concentric circles out of this, what I'm seeing on the Zoom.
And Aaron, is that something that you want me to do, or is that something that would go out from the subcommittee itself to all those entities that's outlined?
I'd recommend it come out through the subcommittee.
Okay.
I do think that anybody on the Zoom, if this were to be resolved, we approve it, that we can also send it all out, but I would also recommend that it come out from Haley and from Kelly, so we can make sure that it does come, if it is approved from this group officially as well. Chuck,
that would be my recommendation as well.
Yep. I think I cut you off, Chuck.
No, that's okay. I was just trying to nose my way in. I'm only talking about the resolution at this point. I do have some serious parts to discuss on the bill itself. And when it comes time to discuss the bill, I'd like to bring those up. But I'm just talking about the resolution at this point is something that with the understanding that it will be circulated for feedback before the consortium decides on it, I could vote yes on that. I
Okay,
won't make the motion, but I could vote yes on it.
then if we can hold off on the vote, I'm gonna do the vote. They'll be separate. I want to do the vote at the same time. So can I have the discussion about the support of the building? We can discuss that now.
Right.
Any
Chuck?
conversation there, Chuck?
Or anyone else? Questions, comments, concerns?
Yeah, the biggest heartburn I have is really between lines 32 and 42. And this is the part about the litigation. We already have situations in the special ed world where the district or the charter school, the LEA, has a legal burden that it really isn't present in most other states. There's some unique things about our state where we get on the hook for certain legal bills that other places in the country they're not. And this language looks like it really mirrors that. And I would have to make that a really hard no, being somebody who works in a district. I think we should take another look at that and maybe rework that. I also don't know, in 33, there's some lines about a law firm that's a not-for-profit corporation. And I'm not quite understanding what that is. I mean, most law firms I know of are for-profit, but does this channel the business in a certain direction? Or are there lots of not-for-profit law firms out there that, I'm not a lawyer and I don't really live in that world, so I don't really know what that's trying to do. But especially the stuff down there in 36 through 42, where the LEA or SEA is on the hook if one claim is prevailed on, and burden of proof, especially if there's going to be money going toward potentially some legal agencies here, I would have to say no to the whole thing based on that. So again, thank you for listening. I do, there's a lot of good stuff in here. I know what we're trying to do, but these are some things that are really a killer for me. Thank you.
And so just to unpack this a little bit, Chuck. So you're saying that the whole idea of referring cases, that's where you have like your heartburn is actually this, and the whole idea of this entity referring cases for litigation that can't be settled. That's your bottom line concern, or
not so much that concept, but the districts are going to be on the hook for a lot. And what happens sometimes in the special ed world is we get all kinds of allegations and so forth thrown at us. And, it's, if one even small piece of that is substantiated, then we're on the hook for the entire legal bill in a lot of cases. And this looks like a lot of that. And I don't know that that's what, the ombudsperson is really intending to do. It's, but I would take another look at that and maybe talk to someone. I see Bill's hand up because he does have some knowledge in this area, but there are some places where I would say the LEAs suffer undue financial hardships on a case-by-case basis because of the way this stuff is written. And in some cases, it becomes a cash grab by the legal firms. I know that this says not-for-profit, but still, I mean, there's lots of not-for-profit organizations out there where the CEOs are making $900,000 a year. So to me, not-for-profit doesn't necessarily solve it.
and the fact that no money has to be paid if the plaintiffs lose. This is only if plaintiffs are successful in the case or in the claims. So the only exchange of any kind of compensatory outcome is if the LEA loses. So that's not sufficient.
I would say listen to Bill, and then I can come back and answer that more. But there could be all kinds of little things, and it could be that somebody didn't sign the right piece of paper by a certain date. They were 2 days later, and I'm not exaggerating. And then the whole legal bill is on the LEA. there's stuff like that that happens. So, yeah, I'm still a no on this one, and it's going to be that way unless this language is really retooled. Thank you.
Bill?
Yeah, a couple of points of clarity. Classy, who is listed here, is the one long-established advocacy nonprofit legal firm. So that was the starting point. The council has the authority to approve others. We just don't want anybody willy-nilly doing this. We want somebody who is responsible and looking after the best interests of the students and their families. So that was the reason we started at that point. And also, obviously, for-profit organizations are going to try to make money on it, and that's not the intent here. As to the burden of proof, that's not a particularly hard thing. And Chuck and I've had some emailing about this. And one of the things that I was implied in the wording, but I think maybe we want to improve the wording in the bill and make it very specific, is that by getting that, it also eliminates the potential for the suit to generate punitive damages, because as we all know, punitive damages are where the huge dollars come in. And I think adding that to the bill would make it more balanced and more in keeping at least with what my intent was in drafting it. You know, we don't want to pull dollars out of the classroom.
So Chuck, is there any language that you could be able to, not necessarily in this meeting right now, but is there any language at all that you could even, you may be able to suggest? Because what I'm hearing is you're not opposed to this office being able to refer cases. You're opposed to the fact that it leaves open the opportunity for LEAs for LEAs to actually be on the, I guess, on the hook and unnecessarily unnecessarily so. I just want to make sure that I'm hearing what you're saying correctly. And if so, if there's language that you can modify, language that you may be able to submit for our consideration.
Well, no, I'm not going to do that. I mean, that's the people who are designing this can come back with something different, but this is still very, very one-sided here. What happens? So here's I wouldn't necessarily want this to happen, but let's go hypothetical. Say we have somebody who is using the ombuds office to harass an LEA, which, you know, that could happen. You could think about it. It can conceivably happen. What's the LEA's recourse in that case? I
hear you, but I don't see how. So you're talking about organization. This is an entity, right? That's outside of the system. So no, that has to go through the processes. Again, we talked about this whole education equity group, right? So no one person would be able to say once that, because it's going to be a couple different attempts, right, to try to get the issues resolved before it even gets to the litigation pieces, right? And so nothing, in my understanding of just how it works, I think it's actually more protection from abuse, right? Because there's going to have to be layers of proof that all attempts to get this thing resolved without using legal means will have to be exhausted, right? So the idea that would open it up for abuse, I just don't, in a realistic sense, how it would operate, I don't think that would happen.
But Shannon, on the other hand, I mean, the entire point around this is some level of transparency and accountability. So Chuck, is there any kind of recourse that you would feel comfortable with from a district view?
I think that what we would have to do is take this and kind of like the other one is run it by the LEAs and say, is this, maybe that's the same question. Is this acceptable to you? I think you're going to get no from you're going to get no from 19 school districts and 22 or 23 charter schools that this isn't the way. I don't know what the way is. Maybe some of the districts and charters could run this by their legal team to see what this is. But I think that if this were to hit Leg Hall, it would have a lot of resistance behind it. I want to make sure, because I know it's hard to see hands. I know Bill's is still up and Mr. Street had his hand up there for a little bit, but I still this would have to be a no. You won't be able to convert me on this meeting unless, I mean, if I had some superintendent saying, oh yeah, this is not a big deal, Chuck, stand down, support this, then I will. But I've seen this in some of the special ed stuff, and it does take advantage of school districts in some special ed cases. So I'm not saying we shouldn't fix, if we're found to be wrong in some way, we should fix it, absolutely. But this leaves us open to all kinds of, plaintiff's law firm, reasonable, customary, expert witnesses, prevail at least one. Yeah, no, this is the same. This is similar language to the special ed stuff. I can't do it. So I'll stop now. I'm going to be a no. This might be like a 6-1 vote. So, I mean, that's the process. But I just had to make my statement.
I appreciate it.
Thank you.
Let's go. Councilman Street, was that a physical hand up that we saw? If you wanted to weigh in, sir?
Yes,
Okay, go right ahead. And then we'll go to Bill and then we'll,
I just want to make the point that the districts are armed with law firms with very high hourly billing rates. And certainly they're in a position that they protect themselves, and far too often with the training that they give the staff, they have children incriminate themselves, and the level of problems that advocates like myself encounter every day, the parents and the children impacted by that need at least a comparable level of protection that the districts already have in place for themselves. And to the extent that districts are losing special education, well, they need to learn to follow the law. You either follow the law and either you're complying with the IEP or you're not. And if not, then you have to endure the consequences.
thank you, Councilman. Mr. Doolittle.
Yeah, just two quick things. There are 2 layers of checks in the bill that prevent frivolous or harassing lawsuits. So that was thought through, and obviously somebody can do that without going through the ombudsman program, but if you go through the ombudsman program, there are those checks and balances. The second is just sort of an impression. I'm quite sure that as we work this with the districts and the charter schools, that we can get to language that, while they might not be excited about it, that is palatable to them. Because this does, particularly if we add the punitive, because in special ed law, there is no punitive damages. If this section isn't in the bill, then the districts are completely wide open to any level of punitive damages that the court would choose to impose, which can be quite extensive, particularly in discrimination suits. So, and I think adding that language in itself is a huge step forward. And I sort of, again, thought it was implied, but after reading it, I think it needs to be specifically called out.
Got it.
All right, Bill. So to move this conversation forward, then, if we could, we'll go back and kind of punch up the language to make it clear in some spots. And I also think it's important to reiterate what this office is for, right? Who audience are we serving here with this office? It's to serve parents and students. It's not to serve the districts, right? We need to work together because it only makes sense we work together. But if we're not doing stuff because, well, the district may not like it, but if it's not in the best interest of our families and students, then we shouldn't be doing it, right? There needs to be an entity that Delaware currently does not have, to Mr. Street's point, that is actually has the students and the family's best interest as their motivating factor, right? As their motivating interest. It's not to say that LEAs don't care about families and students. That's not what I'm saying, right? But they are stacked with attorneys who understand the law. Families are not. And so to the point again, it's specific language that says after, the due diligence and after all reasonable manner of attempts have been made to satisfy the situation or settle the situation, to compromise in the situation, right? I would be surprised if you don't see, but I expect the amount of lawsuits actually go down as a result of this office, not go up, because you're dealing with folks who are well versed in how to support families to navigate through the system. This is a last resort thing. It's not a first resort, right? And so, and again, this doesn't preclude anyone from working outside of the office at all, right? But I think from a structural standpoint, I think putting this in place could actually, and I'm expecting to see the level of those kinds of lawsuits and complaints go down, because now you're dealing with an entity who actually is in the business of working with the districts, not to sue them, but to work them for resolution, and then to begin to actually analyze trends and what's happening, so that we're saying, listen, you got dinged on this. What systems can you put in place? We can recommend that you put in place so it doesn't happen again, right? So I think we have to, and again, I am a family community advocate first and foremost. So that's the lens by which I'm looking through this legislation. So I certainly appreciate everyone's feedback, and comments, but I just want to make sure I don't want to lose the purpose of this whole program in the first place.
So Shannon, I asked Haley to move to line 16, the focus on non-legal interventions as the first part of this. And as a leader of an LEA, I can say, unfortunately, I can be sued at any point in time. And so the hope is that with a group that can call balls and strikes, or fair ones and non-fair ones, that sometimes I have seen independent leaders jump in. Somebody's appealed to that person. They go, no, they called it right. You were actually wrong in this case. And there are times that we as a LEA have gotten things wrong, and so we have to correct those things. If we're not able to correct those and we still continue making bad decisions, I do think the transparency should be there. I am fine with the ombuds program, how it is, with the legal piece being there, as long as I agree with Chuck that if the first thing, if we start off on line 32 and 33, then yeah, I have a problem with that. But if the focus starts off at line 16, then maybe that language is a little bit stronger. So people are very clear that this is before you get to the amount of lawsuits that we've actually looked at this. And I've actually been known to call advocates and say, if we agree to something in this meeting, then I'm going to need you to help me hold that parent accountable, because that was the issue, which has made some advocates either love me or hate me, but we're going to get the work done because I care about the students. With that being the case, I did hear you, Shannon, say that you wanted to pull the bill, because I know it's time's sake and we had 5 minutes allotted to this. I know we have Councilman Street, who's already started his time with public comment earlier. So I did want to know what you want to do, Shannon, moving forward with the bill. Did you want to move to vote on this one tonight? Or did you want to pull this one and we come back to it? The resolution is a separate one, so I want to.
Right. So I will. Here's the thing: can we only vote on stuff or firm stuff in this? In this, like, we couldn't do this through, like, we were to pull the bill and punch up some of the language and some specific questions and then put it out. Do we have to wait for a whole nother month before we could do that?
Good question. Typically, yes. And I know the next Reading Consortium meeting is April. It was in the chat.
April 7th.
April. I was so wrong. April 7th. I'll find the chat. April 7th in the chat. We have done things on email, so if you wanted to go that route, you just risk the conversation. That would be all. So I recommend it in this session, and we're clear if there's some language to be changed, we change it in this session and then vote on that. Or if you do the email piece, there will be some conversation missed, especially when it's a very specific bill.
All right, so I guess I would recommend in that week, if we're gonna vote on the resolutions separate, resolution pending it's going through all of the appropriate impacted folks approval, and that we pull this, we punch up the language of some of the places, and I mean, honestly, my guess is I can think of a handful of LEAs, so I don't care what we put in there. When we say anything about lawsuits or whatever, they're gonna want to be like, oh, nope, sorry, don't want to touch it. And that's fair. I get that. But we can strengthen it in some places, or clarify in some places that need to be clarified, and submit that in time for our April 7th meeting. And
That'll be
then
the full consortium meeting.
the full consortium meeting.
Yeah, it's April 7th. And the only push would be that I would say that every LEA, myself, who's an independent small charter to a large
Mhm.
district, if you have tens of thousands of children, this bill doesn't change whether or not they can be sued.
Right. Right.
So even if you say, hey, we're gonna take all the legal stuff out, it wouldn't change my being open to liability. So that won't change when you change that language, just FYI.
Mhm.
But Chuck is also a very well-respected, my co-chair, but also CFO. And I know the financial side of it. When we get sued, it does come up.
I mean, I you know, the spirit of this thing is to be able to support families and not have to sue, because when you do that, you're actually taking money out of the system to address one specific issue when it's usually broader than that, right?
Mhm.
And anyway, so back to your question then, Aaron. I'm open to pulling it and then punching up some of the language. And someone else had their hand up.
Dean Henry.
Okay.
So I have two questions. Have we consulted? I remember a previous conversation. We were talking about I think Boston Ombudsperson office. Have we consulted legislation for places that are doing this work successfully to see if our language here is fairly consistent with the language that we see in the authorizing bills in other places that do this work? Because it seems like to me that there's just a bunch of terms that a lawyer may know what reasonable efforts have been attempted to resolve, but I don't know if that's a term of art that would be generally accepted. But in the world that I live in, reasonable is in the eye of the beholder. So I'm a little bit worried about whether this language is consistent with, and I know each state has their own system, statutes and laws, but it just seems to me that it might be reasonable to take a look at that legislation and mirror some of the aspects of that here.
Well, I will say, in order the design of the office itself, we looked at other similar entities across the country that was doing this work. And if my memory serves me correctly, none of them do anything around the lawsuit or referring the lawsuit piece that I can recall. What makes that, I think, strengthen in Delaware is because we've had advocates like Jay Street, who's been doing this work for decades, right? And it's a way, again, to find a more structured, permanent place for that to take place.
So if I could ask the second question, I guess that in and of itself worries me a little bit without a broader set of discussions about why the legal remedies are needed. And secondly, line 51 and 52, is this meant to be binding on the legislature? And can we actually require that $1 million that the program be funded? Because that's $1 million out of budgets that go directly to the schools. So I would want to be very cautious because $1 million is worth quite a bit in in our public schools.
Yeah, well, the governor's already agreed to the $1 million. And as part of the settlement, again, let's go back to why this all started in the first place. the funding lawsuit, right? So this was part of the money that was already designed or allotted is what was negotiated in the settlement conversations. And I will leave that to Jay as the one of the plaintiffs. He can address that in much more detail than I can.
Which also, I want to get to Councilman J Street's reason for being here about the settlement too. And I do see more hands going up. I know it's 5:46 and I would hate to shortchange one of our keynote speakers. I do see Bill's hand too. And so before we get to that, Bill and I was hitting you in the chat. If possible, I'd like to move with the resolution, and then we'll come back to Shannon, what you want to do as far as the bill coming back with different language, or if you want us to vote on that, and we can do that part today. But I want to get some progress moving forward. So if you can put the first slide up, Kelly or Haley, I forget who has the controls here. Perfect. Just we get some progress. Resolution, which we all agreed, or I think we did, that we could move for the resolution, and one coming out of the settlement committee, it will be pushed towards the Reading Consortium with the understanding that it would be shared with impacted groups by the our UD staff here from Haley and Kelly, but also can be shared with our own groups. Can I get a motion for that resolution, the first one?
I motion.
I don't know if you should motion considering you put it out there.
Oh, sorry.
Can I get someone else to motion? Okay. This is a motion for the resolution. Okay. I'll put out a motion. I'll first motion to support the resolution with it being pushed out to other groups. Can I get a second? I see Larisha Shutt's hand. If you could just unmute.
Second.
Perfect. All right. With those shifts, all in favor, thumbs up or say aye.
Aye.
2 thumbs up. I see Chuck. I see Shannon thumbs up. So that okay. I see Monique's thing. Perfect. All no for the resolution specifically. Shelly, no for the resolution. I see that hand. And anybody else? Okay. Last one.
That wasn't a no.
I'm sorry. That was a no.
That was not a no. That was.
Oh, that was a yes.
Yes.
Oh, got
Not
you.
me.
Okay.
Do you want me to just run through,
Go
roll
for
really
it,
quick,
Kelly.
Aaron? So we don't do a voice vote.
Go for it.
Aaron,
Yes.
Chuck Longfellow,
Yes.
Tika Hartsock,
I'm abstaining.
Gary Henry,
Abstain.
Shelley Rouser,
Yes.
Monique Martin,
Yes.
Larissa Shutt,
Yes.
Shannon Griffin,
Yes.
Neil Kirschling for Sarah Stowens. You can abstain if you want. Neil.
Oh, sorry. Yes, abstain, please.
Okay.
So we have 6. The motion passed.
Motion passes. So that means that Kelly and Hale will be moving that to share with the full Reading Consortium, as well as to the impacted groups, and we will share with our groups as well. Shannon, going back to the bill conversation, did you want to continue what you were stating, which was to bring that back to this group?
Yeah, we'll pull it and bring it back once we punch up the language a little bit.
Got it. Thank you all. We're going to move forward in our DEO, the featured speaker, Councilman J Street. So before J Street comes, wanted to just outline what was also brought up before, that we are here because of the settlement. That's the reason for our committee from the Reading Consortium. Wanted to have a chance to check in with the head of DEO, as well as there are others in this group. So I know Tika is a part of DEO. and some others. We're glad to have you here and would love to just hear your thoughts on the settlement. And so the next slide has discussion questions that are there, which are what changes to the settlement could be made and how can the settlement working group assist DEO with that as well. You can also add any other context you would like, sir. So we're glad to have you here, and we'll leave those 2 questions up. Actually, we'll take those questions down so we can focus on you, Councilman Street. Floor is yours, sir. And you're on mute. Haley, can you unmute the councilman?
I can.
I got
Oh, there we go. Okay.
I apologize. I'm a pretty good student advocate, but I didn't do well. I don't do well with technology. What I have to say about the settlement, we're actually in the thick of, and with the exception of the ombudsman program, I am very, very satisfied with the progress that we've made to date with the settlement. As a matter of fact, as it relates to overall funding, the governor has, and the General Assembly agreed, put more money in opportunity funding this year than they had to put in accordance with the settlement. So I'm appreciative of that. My problem is the ombudsman program. And quite frankly, it was to the point where I really wanted to forego the program than let it go forward in its current form and fashion. And number one, let me take full blame and responsibility, because we started negotiating early in the morning in the final day of the settlement, and we were at 11 o'clock at night when we finally got to the ombudsman situation, and obviously none of us were at the top of where we needed to be, but there were some things missing that were not included. I couldn't go back and retrieve. And from the beginning, $1 million statewide, in my opinion, was not enough. I think there is some inclination on the part of the governor to reconsider that as we go forward and we see how the program operates and functions, and the number of referrals that they actually get, and based on how complicated they are or not. But the other part of it is, as you're having today, there has been a difference of opinion as to with the people who are responsible for with Department of Education in their interpretation of the settlement as relates to what can and cannot be done. And from my end, we were crystal clear that we wanted lay advocates, but we also wanted to have an opportunity, if it was necessary, for a parent to have the opportunity to obtain counsel to seek relief if that was necessary after all discussions and negotiations had failed. And it was just that simple. But there is, as we speak, a difference of opinion as to whether or not referrals can be made for a lawyer. And we were, in particular, we had talked about community legal aid, and that's where the nonprofit aspect of this comes in. So, but as we speak, I have, not last year, not last month, but last week, a charter school where a kid with special needs was choked by a teacher. Not comfortable in going back to school. It was immediately referred in part to the police and part to Department of Education. And I just don't see DOE as an institution being in a position where they can decide whether or not an advocate can or cannot make a referral to a lawyer. And I can only tell you, and it may not come to fruition, but as I had said before, during and after the negotiation settlement, I've been in the arena now for over 47 years, and there's not a superintendent or principal anywhere that can say I intervened, and that kid who may have had issues and challenges came back to school and did the exact same thing. And my intervention and the way I would help train people is to keep the kid in school, keep the kid out of trouble, get the child the resources. But I work with the children outside of school to see to it that there was some success. And for the most part, districts in most cases respected that. And at the local level, the school level, principals were appreciative of intervention because we would intervene, go monitor the child in school in the classroom. However, with me, it got to the point where I stopped going to school because the minute I arrived at the school went off, it's like a gunshot went off. What's he here for? What happened? And the child would end up enduring consequences just for being the person that caused me to come to the school and do whatever. So even with the case last week, I've given advice, I've made referrals, but I have not been to the school. But these cases don't go away. And we got a similar situation downstate, and the cases don't go away. And I just don't, this whole view that the ombudsman can't make a referral to lawyers, to me is just outrageous. And that's part of the effort. And quite frankly, the state as a state can't have it both ways. On the one hand, they went to court, a district went to court and took the position that lay advocates should not represent kids in special education hearings because they weren't lawyers. And that's because the districts were repeatedly losing hearings as a result of these lay advocates. Now we're saying we don't want lawyers. Then at the end of the day, it just feels to me like we're saying we don't want kids to have advocates, and that's just wrong. We know it's very, very much needed. And I don't know what else. I'm complaining, and I'm hoping it can be resolved. But ultimately, that's up to the governor to reconsider and up to the General Assembly to make a determination on whatever is brought forward to them. But the records speak for themselves. And in my personal history, when I had on the one hand, a case where there was great publicity with an elementary school child, I think in first grade, was going to get expelled from school because he brought a Cub Scout knife to school, and the district voted to change its policy that night. Well, the same night they voted to change the policy for that little boy, and by the way, Cub Scouts don't issue knives, so all that was questionable. But that child remained in school, but they put a 7th grader, they expelled her for having a kitchen knife where she was obviously peeling her apples that her mother had given her to take to school. No, I didn't go to court, but I filed a complaint with the State Human Relations Commission on behalf of that child. I had to end up going to get legal representation, and that, of course, was settled. But on an individual basis, even though I did special education cases from time to time, it's the only time I went in with a lawyer on an individual case and sought that kind of relief. So all this the fact that, in my opinion, the department is resistant to being able to use part of that $1 million for legal assistance is mischievous at best. And that's why I don't think that the department should be the sole and final determinant as to what organization or agency receives the funding. And that's all I have for right now. I'm sure you have some questions, and I'll try to answer.
Any questions, members of the group? Of the
I have
com-
a question. I just have a comment. First of all, I just want to thank Mr. Street for his just ongoing advocacy in this space, in this arena. And I think that just to expand, he mentioned specifically about the DOE should not be able to dictate or delegate if, you know, who's referred out. The LEA should not be able to do that either. So.
Chuck.
Thanks. Is there any process to go back and do some kind of a, I don't know, a meeting of the minds on the settlement where we are and maybe modify or tweak a couple of things like what you're talking about? There's another one it's later on in our agenda, but it's about the supplanting rule. And, you know, it'd be great if there was some kind of a, I don't know, a opportunity for, say, a district or charter school wanted to do something that would be considered supplanting under the opportunity fund if they could make a case, such as, here's an example, just making it up, but it could happen. Say a school hired social workers, and then the opportunity, but said, but in order to do that, I'm going to have to not have a music teacher and an art teacher. And then the opportunity fund comes along, the teachers and everybody in the school says, we want music and art, but we can't go back and get them because we don't have the units. We already used them for, you know, that's one thing. Or maybe like what you're talking about, where the ombuds program can refer to legal. Now, my resistance wasn't necessarily the referral to legal. It was that, and the district is going to pay even if one small minor infraction is sustained. Now that's a whole different conversation, but the question is there a mechanism for the plaintiff and the defendants of the settlement to get together and tweak some of these things at some given point?
There's that opportunity. It's a little bit complicated in that anything that we agreed to change, we'd have to go back to the chancellor for final approval. But in the instant situation, over my objection, which was after the fact, contract had already been signed, and there was no willingness to rediscuss that because I guess there was a fear, well, I'm sure there was a concern about litigation from another aspect. You've already signed the contract. But the other is for things, and I'm sure I should have included this in my opening remarks, but I was one of, if not the only lay advocate that did expulsions and did them pretty successfully. But the organizations that submitted and responded to the RFP, they didn't have anybody that had any experience in representing a child or parent in an expulsion proceeding, which can be complicated. And for things like that, you have to have an attorney. And I had to endure the consequences of after a situation in the Capital School District where I represented a child who basically school officials didn't want to walk across the stage in graduation because she was 9 months pregnant. And all of a sudden there was a quarter credit missing from 9th grade. Well, I went in, found where the record had been altered and prevailed, and she was able to participate in commencement. And then there was complaint about me practicing law without a license. So here again, state state and other officials can't have it both ways. You complain about lay advocates doing the work successfully, and we're practicing law without a license, but you don't want to pay for attorneys. In the meantime, school districts are armed with, well, and there's one major law firm that covers most of the districts. And look at the money. You can check the record. How much money have the district spent in attorney's fees in the last just couple of years? So it's a fundamental fairness issue that I'm concerned about. But the answer to your question is, that was a very long answer to a very short question. I apologize. But there is some latitude, but certainly we need to have that discussion before the next RFP goes out.
So I have a quick question, Jay. So just so that I'm clear, in the current RFP, the organization can or cannot refer for lawsuits and can or cannot act as an advocate in those situations.
It's being discussed with lawyers and the agency as we speak.
Okay.
So the answer to your question legitimately is, I don't know the answer yet.
I know this
I know what
doesn't
it'll
make
be
it
if I have my way, but we'll see.
I know it doesn't make it any better, especially where we are now, but this committee was trying real hard to get at least some ability to put some input in or shape the RFP before it went out. And I think we were essentially stonewalled the whole time. We seem to get a little more opportunity for input on the independent funding assessment, that RFP that went out. But yeah, we tried, but we didn't get much traction in trying to influence that ombuds, because I think we would have seen a lot of things in a similar light.
I could also add to that statement, and Councilman Street, again, thank you for being here tonight. It's been interesting within our committee, we have different ideas, DSU, UD, we have union representation, we have district leaders, we have charter leaders, we have a nice swath of advocates and of incredible foundations. And so we've been working together to try to give input, and we understand our role is simply as recommendations. We have no legal rights in the situation for the settlement. There are times where if we could, I think, have better communication with you, just so we can make sure that we can be advocating in line with the settlement. I think it's a good check for us to go, is this in line with the settlement, or are we doing something counter? And I think the other piece is also knowing that we were in, I know of one battle in particular where we said, hey, we think this should be the case. We got stonewalled. And then DOE came back and said, well, Councilman Street's already signed off, and pretty much gave us whatever fingers or signs you could think of and walked away. And I think it would love to build better communication so that, one, we know our role is not, we have no we are giving feedback and oversight, but it is simply as a committee. But would love to have more communication just so we can make sure that we can be advocating in the right ways.
Well, let me be crystal clear. In my opinion, when you play in this arena, differences of opinion are healthy. Nobody has a monopoly on ideas, and everybody brings something to the table, and the entities that everybody represents need to be heard. So I'm happy to do that. And, at this point, even though we all have jobs somewhere, everybody's volunteering their time because they're sincere about trying to do something to make a difference. And if, I don't know what argument came up that said, I signed off on it, but I don't want to try to act presidential here, but I think that may have been a hoax or fake news, because I don't recall what it may have been. And so I probably need to be able to participate, because it's nothing new about folks using my name in vain, and maybe it did, maybe it didn't happen. But I am doing everything I can, and the ombudsman program was part of my effort to get out of the arena and let younger people come in and participate, try to help in a transition process. And but anything I can do to be helpful, I'm happy to do.
We appreciate you, sir. Anyone else? Perfect. Well, Councilman Street, I can say on behalf of a committee that has been spawned out of your leadership, we 100% thank you for your work within education, also within this settlement. We thank you for your continued commitment to education and advocacy in the state. And we look forward to continue working with you in the future. And also, you have an open door to this committee, sir. We have been honored to have people actually care what we think, but at the same time, we are honored by your presence, sir, and also want to make sure we move in lockstep. So thank you.
Well, everybody brings something to the table. I appreciate your work, and you know, the more that more people from different backgrounds can work together, it's going to be that much more helpful to our children.
I've got one final question for Mr. Street. What's the time frame you think?
You like my closing statement? You like my closing statement, Shannon? You like?
I'm sorry. What we have.
Go ahead.
I'm all about results oriented. When do you anticipate you guys coming to some kind of resolution around this discussion that you're having now with the governor's office around the parameters of the office?
I think they're going to be ongoing, and quite frankly, I think it's going to include whatever you recommend ultimately to the consortium, whatever the consortium recommends in terms of the legislation. So at this point, I hate to say it like this, but we're all in this together.
Thank you.
Perfect. I see the chat about the timing. So 6:30. I see that, Dean Henry. And with that, we're going to move to non-supplanting language. And Councilman Street, you're welcome to stay on. This is actually what Chuck was talking about with non-supplanting. Is there a potential solution? So Chuck, you want to add some more context to that? That was you can follow up from your conversation about the social worker.
Sure. I mean, I pretty much gave the brief version of it. Supplanting is when you have non-supplanting language, typically you see that in a grant, and that tells you that by taking this money, you're going to do additional things that you hadn't funded. You can't take, if you were funding it with a source before, you can't necessarily take and now use the new funding source and supplant the expense from the old grant and free up the old grant for something different. There's, that's a very simplified version of it. But the one thing that I wanted to bring up was, if there is an opportunity to even just have some kind of a process in the opportunity fund, especially where if something were to be considered supplanting, that at least an application could be submitted to somebody somewhere to review it and potentially allow it. If you have a specific situation, like the one I said about the music and art teacher is one potential example. There could be others, but this right now, this would not be allowed because the settlement it actually did have the non-supplanting language in there verbatim from the earlier versions of the Opportunity Fund. So I think the potential solution is, if if the plaintiff and the defendant, at some point, if they're meeting to talk about, tweaks to the settlement, that this be at least a subject of conversation. And I wanted to see if this group either needed to discuss it more or could recommend it upward to the big consortium for them to officially, let the parties know that this is something we're interested in. If it's something that we as a group are not interested in pursuing, I understand that, but I would just like to see if there's any discussion on it, or if it's something that we could make a motion on either this meeting or a later meeting. It's not really a time sensitive thing, but over time, as the opportunity fund grows, you're going to have other opportunities or other situations where somebody may say, well, I already did that, and now I got to either double down on it or figure out something else to do, where a higher value thing might be to do what I originally did. So thank you for listening, and just want to see if there's any discussion.
Just to add to that comment, the statements by Chuck, that is true, I think, for all LEAs. If you are doing the right thing and have already been funding those units, then you are not able to use that same funding for something, use that same funding and then free up some other funding for something else. Just so you do know, I do understand the intent of that law, which has been that there are many times that money has been given to LEAs, districts and charters, and it has then replaced something, and that money goes to something that it shouldn't be used for. So there's potential for harm there. I like the application piece, so we can make sure if you're not using the money for example, this social worker, then where will that money go? And if that's approved by pick the entity, I do think that could make it where it's palatable. The key is that the money's not wasted. So Chuck, I guess I'll ask the question here. Did you want to make a motion now, or do you want to draft something and then share with the group for this? I also know this has been conversation with different legislators recently who would ultimately need to make the amendment.
I think, well, and I don't know that they can really do that without the parties to the settlement getting involved in it. And then, like Mr. Street said, the chancellor being involved. So it seems like it's a whole big process. They would have to do that even to enable the legislators to make that change. I guess, I don't know. I'm not a lawyer. So, but I'm comfortable with bringing something to a future meeting. I just wanted to introduce the concept more officially now, unless people think, oh, wow, this is an urgent thing. Let's do something now, but I'm willing to draft something up for next meeting if that works.
I like that idea.
If I can add, wasn't this, Chuck, a discussion with the reauthorization of ESSA a few years ago at the federal level? So there may be something we can learn from that process. Though I don't think they ever resolved the discussion. So
I don't think they did, no.
it might be worth looking as a starting point for Haley or others if you're working with them on it.
All right.
Okay, thanks. I'll bring it back.
Perfect. Thank you. Next one is Chuck.
All right, so governor's recommended budget came out. Some good things in there for Reading and the Wilmington Learning Collaborative. 10.2 million for the Reading Consortium. 7 million of that is for the Wilmington Learning Collaborative. So far, we know that Christina, Brandywine, and Red Clay have all signed on to discuss the MOU. I've been involved in some of those meetings, so those discussions are happening. There's not really much on paper to report, and I don't even know that it's my place to report at this point, but those conversations are happening. As for what that money is going to be used for, I can't even say at this point because we're still working on the concepts there. The ombudsperson program funded at 1 million. I agree that, depending on what that program looks like, I've said it from the start that doesn't seem like it's enough to cover a whole state. We'll see where that goes. Independent funding assessment is funded at $1 million, and we know that the RFP went out for that. So we'll see where that goes. That had better be a really good assessment for that amount of money, although, others might say, wow, that's all, but it seems like you should be able to get something good for that. Teacher recruitment and retention got in there, and opportunity funding at $38 million. And let's go on to the next slide, because I think we did yeah, we go. There we go. Next one. So these are our graphics on what we should be seeing out of the settlement in future years. I'm moving my checkerboard square of everybody around so I can see it. The orange is what we expect to see in the governor's recommended budget, and finally the budget that's approved by the General Assembly and the governor later on. Opportunity funding, not less than 35 million, and 5 mil should be for mental health and reading. So it does look like they are exceeding that at this point. K-3 basic special education, we know that there's been great movement on that. There's actually units in this fiscal year 2022 budget for K-3 basic special education. And it looks like the divisors are going to move in a favorable direction for schools and kids in 23 and 24. So a lot of good stuff happening there. Next, please. Early education. This is, yes, ECAP. I think maybe I missed it. There was some early education funding. Oh, I think it's part of the Reading money, right? The early education money. Okay, that's something that is of note. So there is some movement there in early education. We all know that is super important in what we're doing here. Teacher recruitment and retention, the $4 million in orange did get put into the recommended budget. Ombudsperson, we had discussions on that. That equity statement for capital projects, that got done, but as I lament every time, it was just done 100% to the letter of the settlement, nothing more. The independent funding assessment, the funding is there. They are supposed to complete that by January 2024. So I think that's the last page of our graphic here, and want to see if there's any questions, comments on that before we move on to public comment.
I have a question, Chuck, if nobody else does.
I hope I have an answer. I might not.
Yeah, I think so. Well, on the independent funding assessment, I saw that this committee put out a recommendation for the RFP, and then I looked at that compared to the RFP, and I noticed one of the things you all recommended was some level of public input at some point in the process, like review or involvement in some way. And so I was wondering if there was any, if we'd heard any update on that request. I saw in the RFP that there's some sort of selection committee, but I'm not sure if we were successful in getting on that selection committee or having some level of public influence. Or, I think the way you all worded it was smart about how to balance independence with local input. But if you have any updates, I'd be curious on that, Chuck.
Yeah, we don't have an official as a committee presence on the RFP committee. I do think that if I remember correctly, I don't have the RFP memorized. I think there is some kind of a public exposure of the findings toward the end. But I'm pretty sure, but I don't want to say I'm 100% sure on that. The RFP, it should still be available on mymarketplace.delaware.gov if you need to see that. And if you can't see that, if you need it, we can try to get that, for anybody who needs it. But I do think that if I remember correctly, on reading the RFP, that some of our suggestions actually were considered. So that's good. That's a big improvement over the ombudsperson process.
Yeah, it looked to me the same way. Like many of the things you all recommended were in there. Just you were all a bit more detailed than they could put into the scope. So that's great.
I want to say thank you for noticing that, Neil, too.
Well, if you hear anything, if there's any other plans to try and make sure that there's any public involvement or input, would be interested in helping figure out how to make sure that happens.
Got it. Any other comments or questions for Chuck before going to public comment? Perfect. And with that, Kelly.
If you have public comment, either raise your hand or put it in the comments. And I see Bill, you have raised your hand. You have 3 minutes.
Thanks. Try to make it quick. To Dean Henry's one question. Once the draft legislation is stable into its substance, it will go to Legislative Council for all those nice cleanup stuff. They do a really nice job of that. And as to process to try to tweak the legislation, again, I have a lot of confidence. I'm assuming Mike Stafford will probably be the lead on that for the districts. So quite honestly, I have a lot of confidence that if, me and him and whoever else is involved is sitting at a table in 2 hours, we can clean this up to where the differences are very narrow and it will generally be acceptable to everybody. So that's just my impression. A little bit of good news. I have had indications that DOE is relenting on the litigation support. I don't have final details or even significant details, but it sounds like their hard no is no longer a hard no. So hopefully we'll hear more about that. And just so you know, in my meeting with the secretary and his team, the issue of trying to figure out a better collaborative process when we're trying to develop these type of RFPs was brought up and heard. So it at least is on the table. And I also am supportive of trying to figure out something with the supplant process to make sure that dollars are going to the best possible place. Thank you.
Thank you, Bill. I also want to publicly recognize Bill. Thank you for consistent working in advocacy and also revising things. There are many people you can talk to and say, hey, here's some ideas, and Bill will actually take those ideas and make sure he follows through. So I want to publicly recognize you and say thank you as well.
Any other public comment? All right.
Perfect. So our meeting's April 11th is the next one. Full Reading Consortium will be on April 7th, and then following that, we'll have one on May 23rd. Thank you, everybody. It is 6:28. We still made time, so that's impressive. Appreciate you all. Thank you.
Thank you.
Thank you.
Bye-bye.
Evening.